I am excited because today we have a special guest. Attorney Adrienne Watts is with us. And as I mentioned before, she has an amazing amount of experience, over 30 years actually, as a practicing attorney, working for even the city of Detroit. And in her own private practice, she has been exposed to all types of scenarios with regards to wills, trusts, estate plans. As I mentioned, as you're getting your final affairs in order, being proactive and not waiting to the end and, getting your affairs in order and having something prepared for your loved ones to pick up and be able to execute your final plans. One of the things we talked about, in addition to having a binder and having the information sheet, is to figure out what documents you want to have there for you. Is it a will? Is it a trust? What type of documents you want to have. And so that's why I'm glad that Adrienne is with us, and you will hear her voice, and she will give us some great advice. I'd ask, that everyone get their note paper and pencils out, because she is going to be bringing the knowledge. And Adrienne, I appreciate you being on with us today.
Oh, well, thank you for inviting me, Terry.
No problem. So, Adrienne, as I mentioned to you, I've been just telling people about the process of organizing a binder so that they can have things prepared when they finally have their transition. And, we're not trying to say that people are leaving soon, but whenever it does happen, we want to make sure that all the final affairs are in order. So we've been talking to people about organizing a binder, putting together information sheets. We're going to soon be talking about securing insurance, life insurance for burial and things of that nature, and legacy for your family. And the other thing we want to make sure is that we have a proper way to assure that assets are distributed in the way that that we like them to be, or that your affairs are organized. So, what would you say is the number one thing that you would advise people when thinking of how to prepare for that inevitable time?
To have all of their information, or as much information as possible, together in one place. Doesn't have to be anything fancy. You could take a loose leaf binder and put sheets in it, or you could just take one of those school type notebooks and just write everything in there. I just visited with a lady the other day, and that's what she had done. She had everything in there. So all her son and daughter have to do is refer to that notebook.
Perfect. I feel like I paid you to say that, because that ties right into the binder that we've been talking about. That is awesome, because we've been talking on Facebook, and a couple people did say that their parents, when they passed away, had a binder, but then others said, "Oh, I wish my aunt or I wish my dad had a binder like that." So I'm glad to hear you, validate that that's something that helps with the whole organization process, and that you actually have clients that have used this strategy, because that's what we're trying to really get people to do, is to use that strategy of having a focal point of one place to put stuff. So I know that in the past I've seen your workshops and your presentations about wills and about trusts. And I told my audience, I am not an expert nor an attorney. So that's why you're here, because I would love to hear more about what is the best time, or what is the best time to get your will or trust in order? And then what's the best one to get for each individual?
Well, the best time to get any of your affairs in order is when you're healthy, when you have all your faculties, when you just everything is going well for you. That's the best time to do it. That isn't usually what people do. They wait, in many cases, way too late to do some of the things. But the ideal time would be, of course, when you have everything together in terms of your mind and what you want to do. Now, over a period of time, some of that might change. But as I was telling you earlier, you absolutely have to have a will. It's not will versus a trust. You absolutely have to have a will that you do yourself, because if you fail to do a will, then the state of Michigan or whatever state you live in has statutes on the books that will say who gets your property if you die without a will. Now, when you have a will, you're called testate. That's testate. If you die and you do not have a will, then that's called intestate. intestate. When you die without a will, the state of Michigan will decide who it is that gets your property, and it's going to be based on who's your closest next of kin. So, for instance, if you had someone that you wanted to leave things to that was not related to you or was remotely related to you, and you die without a will, the closest next of kin to you will be who will get your property. So that would be your spouse, possibly your kids if you have them. If you don't have a spouse or kids, then it's your mother and father. If you don't have a mother and father, then it's your brothers and sisters. And in case any of them have predeceased you, then any children they leave will be the ones that'll step up to their parents' position. Now, if you don't want any of those people to get what you have, then you have to write it down. So it's just plain and simple. If you want to leave things to your church or sorority, a goddaughter, godson, your university, you have to write out a will, because if you die without a will, they will never get it because they're not considered heirs or next of kin. It's plain and simple. You have to do a will.